Hey everyone, it's Rob Ryder. Yeah, been a while, maybe 3 weeks or so since I did a video. Quite a few things were going on at the time, including having my power shut off and going to a court case for my nephew, who, after really pondering what had happened, my nephew Matthew spent like 7 years in some kind of confinement for stealing a pack of cigarettes. Go figure. They call it retail fraud. What did you do? Stole a pack of cigarettes. Wow. Oh my gosh, oh my golly, that's how crazy the world is, right? So we got to get this figured out. So this video is about probate versus the Pharisees, the Scribes, and the Nicolatianes, those that would like to lord over you. And I've looked at the probate court before and said that's where we should be going because it's the court of the ordinary. But never really could figure it out. Always seemed to be something missing, and maybe, seen a couple things the last week or so. I said, oh, maybe this is why. And so we're going to look at that. So this is Rob Ryder, and it's Thursday, August 6, 2015. My email is courtofrecord@aol.com. Although I shut off right now because I can't pay my frickin' bill. What are you going to do? Phone is 616-712-6179. And that should still be on, and I believe it will be for the time being. So if you can, please donate. I got to get caught up a little bit. If you can't, it's no big deal. But if you can, the PayPal account is ashleyritlewski@gmail.com. That is the PayPal account. Or you can send by snail mail to myself, Robert Ritlewski, 10955 14 Mile Road, Northeast, Rockford, Michigan, 49341. So let's see what, let's see. This is, this was something that, because of what had happened with my nephew, I wanted to study probate again, and without getting into all that, here's some real interesting things that I found. In Georgia, it says, a judge of probate as clerks thereof. The judges of probate courts are, by virtue of their office, clerks of their own courts. Well, what would that mean to us? You're trying to put something into a court. They tell you, give it to the clerk of the court. Well, then, you would send it to the judge. Right? That's what I'm trying. I said, okay, well, that means I send it to the judge. I don't take it to the window with the all-caps probate court. I take it to the judge of probate, who's also, by virtue of their office, the clerk of their own courts. And he'll do whatever needs to be done with it. And so I just recently submitted one. In fact, maybe they got it today, against the power company. Because as it turns out, they're not the power company. Well, we'll get into that more here in a minute. But so first we do a little bit of history on probate. So this came out of someplace in Ohio. The term probate comes from the Latin word probatio, meaning to prove, wherein matters in early English religious courts were proven by an ecclesiastic judge. Right? So it sounds like the guy who's in charge of probate, at least at one time, was an ecclesiastic judge. It's a church court. Early American probate courts may be tracked back to English courts of chancery. Well, that would make sense, right? The English courts of chancery. Now, that is a royal church court. It's not the Church of England, it's the court of chancery, which was overseen by a bishop and or cardinal, or overseen by the chancellor of the king, which was usually an ecclesiastic. Track to English courts of chancery and ecclesiastic or religious courts. So those two are different. Courts of chancery aren't ecclesiastic or religious courts, but they do have them, which had jurisdiction over probate of wills, administration of estates, and guardianship. The first probate court in the United States was established in Massachusetts in 1784. Similar courts were subsequently established in other states under the name of surrogate, orphan, courts of the ordinary. The Northwest Ordinance of 1787 provided for the first probate judge and the court in Ohio Territory. Under the first Ohio Constitution, the Court of Common Pleas had exercised jurisdiction of probate matters, lowercase Court of Common Pleas. All right, the common Court of Common Pleas, not something that has a title, Court of Common Pleas. The Constitution of 1851 removed the probate matters from the jurisdiction of the Common Pleas and created in each county a separate probate court. Subsequent amendments to the Constitution, blah, 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 blah. Now, this is the important thing. Every county, it's the same in Michigan, they have their own probate court. Each county does, which is different than the circuit court, which may be in the county, but it may have two counties, or may have, a piece of one county, or things of this nature. But these are in each county. And so, from the research I had done before, because the probate judge has not only judicial, but mainly he's got administrative powers, he's actually representing the governor in the county. Now, this county we're talking about is the subdivision of the state, and the probate judge is the administrative end of the state within the county. That's different than the county that is a body politic, body corporate, that has been created within that defined territory, and it has its own courts. Because it's a private, it's a society that you can be a party to if you want to. And that's where they have us now. They got us stuck in that black hole over here, this body corporate, body politic. But there's no record of us ever being put into the state system through the local administrative body, which would be the judge of probate, in my opinion. And that's what we're going to build on. Each of Ohio's 88 counties has a probate division of its Court of Common Pleas. So remember way back when I did some deed, I think it was probably one of my first videos, accept the deed and be the owner. Well, let's read what this has to say, because this was some of the stuff that had to do with that at the time, and, it's amazing what you pick up afterwards. That whenever any circuit court, court of chancery, probate court, or other court of record in this state shall have rendered any final judgment or decree by terms of which any person or persons shall be decided to be the owner or owners of any land in this state described therein. So who can determine if somebody owns land? Circuit court, court of chancery, probate court, other courts of record. Okay, well, probate court, good enough for me. Or where any person or persons shall be determined to be heirs entitled to inherit the lands of the deceased owner, or whether any land shall be distributed, assigned, or partitioned, blah, blah. A copy of such judgment or decree, duly certified under the seal of such court, may be recorded in the office of the Register of Deeds. Again, this is the common case Register of Deeds, lowercase. It isn't necessarily the title of an office. It's the function of an office. Of any county or counties, blah, blah, blah. Okay, so then we go on. Alienation by deed and proof of recording of conveyances. Proof. What did we just talk about? What's the court of proof? Probate. Certificate of acknowledgement or proof of execution, effect on rights to have deed recorded. A certificate of acknowledgement, that's what we were trying to do in the past, of any deed or any proof of execution thereof before a court of record, signed by the clerk of such court. Who's the clerk of the probate court? Well, in Georgia, it's the judge, so signed by the judge of probate. Before whom the same was taken as provided in this chapter, and in cases where the same is necessary, the certificate required in section 11 of this chapter shall be entitled the deed with the certificate or certificates to be recorded in the office of the Register of Deeds of the county where the land lies. And we got two counties. We got the county, which is the administrative end of the state government, and we got the county, which is a body politic, body corporate. And that's the one where we keep putting our paperwork. When you go into the office with the all caps Register of Deeds on the door, you walked into the body politic, body corporate, not into the administrative jurisdiction of the state. But what was interesting about this is what it had in the footnotes for the former law. So this is through time, right, starting in 1805 and kind of goes on from there. Deeds might be recorded in the office of any clerk of the court. Well, that would, back then there was probably only one court, so there you go. Later on, 1815 required them to be recorded in the office of the register of probate of the district in which the lands were situate. Well, there you go. So where was the register of deeds? Well, it was in the register of probate. 1820, deeds were recorded in the office of the register of probate for the county or register of the city in which the land was situate. The office of register of probate was abolished, and deeds, except of lands in Detroit, were required to be recorded in the office of the register of deeds elected for each county. Now, there is somebody who's elected called the register of deeds, but that's the body politic, body corporate. I just think the only person who's actually representing the state in the county is the probate judge or probate division. And that's where the deeds are. I mean, a will is a deed. Writing under seal delivered is a deed. Deeds are used for conveyances and contracts. Right? So if you're going to call it a will with a capital W, that's just a deed. Lowercase will is just by your will, your expressed intent to do something. What you wish to have done, that's your will. Protected individual means a minor, this is in Michigan now, means a minor or other individual for whom a conservator has been appointed or other protective order has been made as provided in Part 4 of Article 5. Oh, well, what's a protective order? Well, that's like an injunction. So they can issue injunctions. Interesting. But what was that Part 4 about? Protection of property of an individual under disability or of a minor. Upon petition and after notice of a hearing in accordance with this part, the court may appoint a conservator or make a protective order for cause as provided in this section. The court may appoint a conservator or make another protective order in relation to an individual's estate or affairs if the court determines both of the following. The individual is unable to manage blah, 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 for a bunch of reasons. Well, one is detention by a foreign power or disappearance. And that's exactly what's happened to us. Our proper person, Robert Allen Rytlewski, proper case, he doesn't appear anyplace. If you go to court and you look at the docket sheet, it's going to have Rytlewski, Robert Allen. If you have a passport and you look at it, it has your name, Rytlewski, Robert Allen. If you have a driver's license in Michigan, it doesn't have you. It has your property as having the license, and that's your all capital letter name. That's the name of your estate. And basically, we're being detained by a foreign power because we're in United States of America, not the United States of America, which is if you go to the Articles of Confederation, first article, the style of this confederation shall be the United States of America. That's the proper name of the confederation. You look at your passport, the is not in it. It just says United States of America. And if you go to the first paragraph of the Treaty of Paris from 1783, you'll see that King George III said he's the king of United States of America. Different jurisdiction. And that's the jurisdiction we're in now. But we're there as Rytlewski, Robert Allen, instead of Robert Allen Rytlewski. And I believe that's because the federal government went bankrupt. Maybe the states went bankrupt. I don't know. But I just know that the place that we've been led to believe is the county as a body corporate body politic, it's its own little entity. And nothing from there is getting to the state that has to do with your benefit because you're not taking it over to the state. how do you get it to the state? You take it to the administrative arm of the state within your county, which is the probate court. But the probate court's clerk is the probate judge. So you don't take it to the probate window, you mail it to the judge. And again, I'm not saying any of this works. When I talk, I'm just saying this is how I see it, how I'm going to go try it. When it works, by God, I'll come back and tell you. But until then, I believe it will work, so I talk about it like it is going to work. But I don't know that it is. Okay, so let's see what some of the things a probate court can do. Because all these, probate is really going to be the same anywhere. It doesn't really matter what it's called. It matters what the functions are, right? What it's doing. So let's go look for some more things it can do. There was this little pamphlet I found here. Oh, let's go to the first page. How do they have this thing? I got it ass backwards. So this is Georgia Probate Courts, presented as a public service by Probate Court of Bibb County. Okay, so if you wanted to find this yourself, just put Probate Court of Bibb County, and you can probably go right there, and you can have this little thing to look at for yourself. But I'm mainly interested in just a few things on it. Introduction. The probate court in Georgia are courts of limited or special jurisdiction. Each of the 159 counties in Georgia has one probate court and one probate judge. Now, in Michigan, we got more than one probate judge, but if there is, then there's a chief probate judge, and it specifies, when it's talking about what's going to happen, the chief probate judge, chief probate judge, chief probate judge. I would say he's the chief probate judge. Here they only have one judge. Probate judges are the successors to the position originally known as the ordinary. There you go, court of the ordinary. Before the creation of the Board of Commission, which today govern the affairs of the county, the ordinary was the chief administrative officer of the county and ran the county's business. While in old English law, he would be considered the sheriff. Many of the administrative duties and functions of the probate court derive from that fact. I think that's doublespeak for saying they still had the same powers they did before, right? And it could be the Board of Commissioners, because this is proper case, it isn't uppercase, is because they talk about 3 judges making up the court, right? They don't all have to sit in court, but there's 3 judges that make the court of probate. But that was where it was called the court of the orphans court. Anyways, I haven't really had a chance to do this yet, but I'm going to go on to YouTube and just put in history of probate court and go find something to listen and read to and see what kind of stuff they tell you. Okay. But anyways, at one time he was known as the ordinary. Well, an ordinary is a bishop. And the court of the ordinary was the court of the bishop. Okay, blah, 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 blah. Probate courts have exclusive original jurisdiction in certain categories of cases involving decedent estates, guardianship, minor guardianship, involuntary treatment of persons suffering illness, addiction or abuse. In addition, probate court perform other judicial, administrative, and ministerial functions. It's because the judge of probate is representing the governor within your state or within your county. I'm not saying the governor who's been elected either. I'm just saying whoever they say the governor is, this is his representative. The true probate court itself, because there's only one probate court in each there's not one probate court in the state. Now, I may have divisions all over the place, but as I understand, there's only one probate court, so there's really only one group that's in charge of it. Because it's a state function, that's being done locally by the local court. This guy down here at your local end, he's the administrator. I don't believe he's the actual probate judge. I think he's more like the probate registrar who has the same powers as a judge. I don't mean to take away from them at all. I mean, I hope they have all the power that they need and make things happen. But here's the additional functions. Probate courts perform other judicial and ministerial functions, including but not limited to maintenance and upkeep of all public records. Who has the public records in Georgia is the probate court. And administer proceedings in the court. Acceptance and maintenance of funds as custodian for missing heirs and minors without conservators. The enforced disappearance of your proper person makes it so you're not the heir of your property. You're the missing heir. Your property is your all capital letter name, which is registered in the state. It's on your driver's license, at least in Michigan. So the state knows that my property's here. It just doesn't know that I am Robert Allen Radlewski. I am its proper owner. As I pointed out in other videos, it looks like they didn't send your proper birth information to Social Security, and a guy with a middle initial ended up being the owner of your Social Security account. So on mine, where it should be Robert Allen Radlewski, it says the owner, because I have the stub that came off the card. It says, the name of the owner is on the other side of this card, and you flip it over, it says Robert A. Radlewski. Well, that just clouded the title to that property, because it isn't Robert A. Radlewski's property, it's my property. But hey, this guy can clear it up, I'm hoping. Maintenance of funds, and then here's a big one. Issuance of residency certificates. Well, that's what we don't have. No, see, we're not registered anywhere in your proper person. We're being treated like a decedent in tombstone jurisdiction, and that's why it's Radlewski, Robert Allen, because that's the way it shows up on a tombstone. Without the comma, maybe. Issuance of license to conduct a business by veterans, issuance of permits to perform public fireworks displays, filling vacancies in certain public offices, administering oaths to public officials. Well, that's interesting. You mean if the probate judge didn't issue, if it's not the probate judge that signed off on the oath, well, then it wasn't properly done. Acceptance, approval, and recording of bonds on certain public officials. Right? We're always looking for these bonds and stuff. They're with the probate court. And issuance of warrants and holding of commitment hearings. They can issue warrants too. Good stuff. Probate courts also hear cases involving removal of obstructions from the road. That would be your car when they pull you over on the side of the road and they give you this ticket. They're going to say, hey, you were obstructing the road. You don't have a right to be on the right-of-way. Right-of-ways are built on private property, and you don't have a permit to be on that private property. Now, you should, but they won't let you properly register. It's the only reason you don't. You didn't register. So, you don't have a legal presence in the state. You're not legally authorized to be on the road. Right now, we're all stateless, vagrants, right? So that's how we're treated. Together with the sheriff, the clerk, and the superior court, probate judges designate the official legal organ. Okay, so they pick what newspaper. So it isn't just any newspaper. There is a particular newspaper where public record needs to be put into. Who picks it? The probate judge. I didn't mean to go past this, and they issue marriage licenses. I got to think about that, because it seemed to me you go down to the township hall to get your license, and then you take it back to the county clerk, but you're taking it back to the all caps county clerk, and it should have gone to the lowercase county clerk, which is the probate judge, because he's the administrative clerk for the state within the county. In certain counties, the judge of probate serves as the superintendent of elections. Yes, he does, and there is nobody here who's been properly elected. All right, so all the state offices are vacated. This Everything else that you see is body politics, body corporates that have been set up to simulate being what the state is. Many, if not all, but not all, proceedings filed with probate are initiated by the use of some kind of forms. Yep, you could use their forms, or maybe you can just send them a complaint. So, okay. Now, where are we going to go from there? Let's look at, well, I did most of my research on Michigan because I had to use it for something here, so we're going to look at that. So sometime in the past, they added a thing to probate, like in 2000. It was called the Estates and Protected Individual Code. And so they created this little thing we're looking at now. I don't even know what it's called. Doesn't really have a name on it. But it had to do with this, how it affected the probate code, which was already in place. So this is what happens in probate. Probate court jurisdiction. Since probate court is a statutory court, let's stop right there. Statutory court means it was created by Congress. In English law, statutory courts are the highest court. Period. Just go read Blackstone or Lord Coke. The courts of Parliament are the highest courts because they can make the law and they can disband a law or not follow law. They can do whatever they want, right? They can write their own law. And that's what we want. It doesn't matter what it says, because the problem is things say what they say, and we need somebody who can just cut the Gordian knot and say, well, yesterday it said this, and today it's going to say this, and not go back and try to undo all the paperwork, because we would be forever. All we want is an accounting of the account and have it put in our name. We appeared, and now to comply with the Cestui Que Vie Act of 1666, we have to appear before the proper magistrate. I say it's the probate court. Asking for an informal status hearing. Just like Rich up in Alpena was told 2.5, 3 years ago by the probate judge himself. It sounds like you want a informal status hearing. And, at the time, Rich said, well, I don't know if that's what I want. I said, well, but it went on. And we never really followed up. And that's my fault. It's like, jeepers, man. I could have done it. But I didn't. So slap yourself and move on. Since probate court is statutory court, historically probate jurisdiction has been narrowly prescribed by the Michigan jurisprudence. In 1989, the legislature amended and gave probate court equitable jurisdiction. That's the Court of Chancery. 1992 amended to provide filing of a civil action in probate court under certain limited circumstances. This rule offered an alternative forum for the resolution of legal disputes. However, the amendment did not expand probate court jurisdiction. So you can file a civil case into probate court, and the reason you might want to do it is because it's a court of equity and not a court of law. In courts of equity, you don't have to be quite so precise, but in courts of law, your paperwork has to be pristine and clean. It has to be perfect. The chancellor don't really care about all that stuff. He's just going to listen to the facts and say, you know what? It sounds like you're right. And issue an order. I don't want a hearing. I just want him to issue an order. I want a declaratory judgment, and the probate judge can give one. Probate court has exclusive jurisdiction to settle accounts of all fiduciaries. Well, who are fiduciaries? It's anybody who's taken a frickin' voluntary oath to do something. And because they took the oath, they were given certain powers. Well, that would be a attorney at law. It would be these people who say that they've been elected, but really haven't been. It would be the people at the township hall that is the place you should be going to court in the de jure, I wouldn't be going to the county. I'd just be going down to local township hall. Every 6 mile square has one, and they should be the court of first instance. And I think that they are in a way, but the fiduciaries, the trustees, and what all they're doing there is so when you get a ticket against you, you don't go to the township hall like maybe you should to take care of it, and so then they send it over to, or they could send it over to probate, but they don't. They send it to a place called the 63B District Court, which is one of those courts that's in that corporate body politic, the black hole that really isn't attached to the state. It's not a state court. So, so you were really never charged with anything, and it's all fake because they never did go. They won't have sent it to probate. But what we should do now is take our tickets and we should send it to probate and say, Judge, can you look at this? I don't believe this to be proper. Probate courts have exclusive legal and equitable jurisdiction over matters relating to the settlement of a deceased person's estate. If at the time of death the person was domiciled in the county. Domiciled, that's big, right? You want to be domiciled in the county. Or was domiciled out of the state and died owning assets within the county to be administered. And that's what we are now, is we are domiciled in United States of America, not domiciled in the township of Oakfield, Kent County, Michigan. That's really where I'm domiciled at, or should be. Examples, we don't need to look at that. Jurisdiction includes, but not limited to, internal affairs of an estate, estate administration, declaration of rights involving estates, devisees, heirs, and fiduciaries. Well, there you go. Let's go get the declaration of rights over the estate. Determination of heirs. If you're a Christian, I believe this is where you're supposed to take your baptismal certificate and have it registered so that the civil society sees that you're a Christian and they can't take you to the Jew court anymore. Right, where it's okay to cheat a Gentile, because if you're not a Jew, well, then you're a Gentile, and in Talmudic law, we can cheat you in business and we can cheat you in the court. Remember, only those assets held in the decedent's name alone are subject to probate. Okay? Examples of assets that must be probated: real estate, bank accounts, stocks, bonds, personal property. Right? Must be proved who the frickin' owner is. Forget the decedent, just proved who owns it. And then other ones, joint owned, bank accounts, stocks, bonds, okay. Things that are owned jointly. So what we want to do is determine who owns the property. Right? That would be the first thing. Well, is it owned jointly or is it owned by me? Who owns what property? And they can prove all the property that's in your name yourself as yours. Only those assets held in the decedent's name alone are subject to probate, are subject to proof. Well, let's prove whose is whose. Okay, practice point. A personal representative is your client, not the estate. This must have been written by the Michigan Bar for attorneys. Right? So the personal representative is your client, not the estate, the personal representative of the estate. Unfortunately, you're not the personal representative yet. Provides that an attorney who files an appearance on behalf of a fiduciary represents the fiduciary, not the estate. Well, that sucks, right? So nobody's looking out for your behalf. They're looking out for the behalf of the guy who was put in charge of your estate. Mistakenly, heirs or devisees of an estate often think that they are lawyers, that as the lawyer for the personal representative, you are actually working for them and will do whatever they ask. Well, that's a mistake, apparently. They're not working for you. Probate courts have exclusive legal and equitable jurisdiction over proceedings concerning the validity, internal affairs, and settlements of trust. Let's stop right there because that is lowercase trust. You go look up trust in well, I shouldn't say it because I looked up trust, T-R-U-S-T without the S. So, but if you look up trust in Webster's dictionary, right, it has nothing to do with property. It's got like maybe one or two definitions of 10, 12 definitions about what trust is. And trust is, I trust you to do the right thing, and you trust me to do the right thing. Right? And they didn't do the right thing. We had a contract, and they didn't do what they were supposed to. Well, that would be a breach of trust. Or I signed the contract, and they were supposed to sign it, and they never did. Well, that's a breach of trust, because they took my property. Probate courts also have jurisdiction over administration, distribution, modification, reformation, termination of trust, and declaration of rights involving trust, trustees, beneficiaries of trust. So they can still determine who the beneficiary is. Excellent. I say I have a piece of the public trust. Right? That was the whole idea, was they took all the titles to property and put it in the big kitty of the public trust. But I have one share, just like you have one share. One share, one share. We all have a share of the public trust. That's one way to look at it. Jurisdiction includes, but not limited to, the following proceedings. Appoint or remove a trustee. Well, that'd be like somebody down there at the township hall. Review the fees of a trustee. Require, hear, settle, interim, or final accounts. Ascertain beneficiaries. Who's the beneficiary? Determine any question arising in the administration, distribution of any trust. Right now it doesn't have the S. Trust. I trusted you to do the right thing. We're supposed to have a business agreement. We both signed the agreement. That's a business agreement. If only one of us signs it, well, then it's an incomplete business agreement, and you're not going to say, well, I was giving it to you as a inter vivos trust, which is a donation. See, here we're using capital. Now we're using proper case trust, right? So this is like a proper, some entity or some document created that's called a trust. Or I believe the lower one is more lowercase. It just has to do with, what it describes. Guardianship, conservatorship, probate court's exclusive jurisdiction over proceedings concerning conservatorship. Probate court can enter protective order. Excellent. They can do fiduciary accounting. Fiduciary is liable for loss of an estate that arises from embezzlement by the fiduciary. Go figure. In response to an interested person's petition or on its own motion, the court may at any time order a fiduciary of an estate under its jurisdiction to file an accounting. So I'm just saying that our Social Security, lack of a better term, anything under your all capital letter name, is your property. It's all being recorded in probate. The problem is there's a fiduciary that's been appointed to it because we've never shown up to claim it. And now we're going to go show up and claim it and saying you would like to have an accounting by the fiduciary. Concurrent jurisdiction. Now, that's where it gets good, right? Because even without that, it has other things it can be used for. Probate courts have concurrent legal equitable jurisdiction over the following matters involving the estate of a decedent, protected individual, lowercase trust, I trust you, just a business contract or award, to determine the property rights and interest. Contract disputes by or against an estate, ward, or trust. Authorize specific performance of a contract in a joint or mutual will. Right? Again, lowercase will, and not will like, you're dying, just whatever your will, your mutual will. It was a contract. Joint or mutual will. We both signed the paper. That was our intent. We expressed our will. or of a contract to leave property by will. Right? To leave it because that's what we wanted to do. Not because the piece of paper says it's a will. No, it was what we wanted to do. Ascertain survivorship of persons. Well, this is what we need right now. We got to have them say, hey, you're alive. My God, this is your property. Determine, right? Gifts, grants. So here's that thing with the gifts, right? That's an inter vivos trust. And they want to make it look like you're gifting your property. It's a unilateral contract. Only one party has to sign it. That's what happens on a deed of trust. Nobody else signs it but you. Oh, you're just giving it to us. Thank you very much. Right? And so when you had these things that were improperly formed contracts, under common law, you couldn't reform the contract. But you could in a court of equity. Let's see. General tort jurisdiction. Wrongful death and other general tort actions must be filed in the circuit court. Okay, well, I'm not going to do a wrongful death. Or general tort. See, I don't know what general tort is. We're going to do civil actions. Vest the court with concurrent jurisdiction over contract proceedings by or against an estate, ward, or trust. It's got jurisdiction over contracts. And it has equitable jurisdiction. Alleging illegal malpractice. I don't know if that worked there or not, but you can, right? I'll show you. That's one of the things I did. Use of subpoenas, blah, 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 blah. The probate court has no authority to adjudicate summary eviction proceedings or any other variety of landlord-tenant controversy involving either property owned by an estate or disputes in which the estate is a tenant. However, it can determine who owns the property. Because in Michigan, they use landlord-tenant law to kick you out of your house because you don't have the legal title, because the closing was never completed, and you don't have the fee simple title in your hand. Where's the title deed? Not the warranty deed, the title deed. That doesn't show. Right? And that was the very first thing we talked about taking to the probate court evidence that the title deed is now yours, right? That you've accepted the deed. And now you're the owner. The following actions must be titled civil actions, commenced by filing a complaint. Now this is where, because now this is what we're going to deviate, right? Or this is what I used it for first. The following actions must be titled civil actions, commenced by filing a complaint, and governed by the rules which are applicable to civil actions in the circuit court. So it's just go file the circuit court's civil proceedings. Probate court has implicit discretionary authority to order garnishments, executions, and credit exams to facilitate the enforcement of a party's judgment. The probate court can do everything. They can rule on the facts and then issue the order and have it executed. And exercise the jurisdiction vested in the probate court by law, the probate court shall have the same powers as the circuit court to hear and determine any matter and make any proper orders to fully effectuate the probate court's jurisdiction and decisions. The statute appears to confer considerable authority upon the probate court, including the ability to authorize the use of garnishments, executions, and credit exams to enforce its judgments. Apparently gives probate court the ability to utilize executions to enforce its judgments, right? MCL. It's telling you where to go look to find these different things where the power came from. Whenever the judgment is rendered in any court, execution to collect the same may be issued to the sheriff, bailiff, or other proper officer of any county, district, court district, or municipality of the state. Judge can do it all by himself. The rules of this chapter apply to circuit court and in other courts as provided by law, which is why we can use these particular things with civil actions. So, implicitly authorizes the use of garnishments in probate court. This, it appears, is pursuant to MCR 3.101. Post-judgment garnishments could be ordered by the probate court. The following sections, the court of record in this state have the power to issue process of subpoena requiring the attendance of any witness in accordance with court rules to testify in any matter or cause pending or triable in such courts. And they took a section out here that had to do with and the court can also render you an oath, but it can devise and make such orders as necessary to carry into effect the powers and jurisdictions possessed by them. Upon affidavit showing satisfaction of the judge, any person has money or property of a judgment debtor or is indebted to him, the judge may issue a subpoena requiring the judgment debtor or the person whom or both to appear at specified time and place, to be examined on oath, or produce an examination of the books, papers, or records. So this is after they've taken your property and now you're the judgment debtor. You can put an affidavit into the probate court and say, hey, he's got my property. I may be the judgment debtor, but he has my property. Right? Because he lied, cheat, and steal. And now we're going to go look at the books, the papers, and the records. Form of commencement. Civil action. Okay. Provided for procedure for probate court is governed by the rules applicable to other civil proceedings, except as modified by the probate rules. Okay, well, that was a lot of that just to say, well, what does all that mean? And this is kind of what the steps are then. So, because it said to do it by, basically by the civil procedures. And what does that tell us to do? Well, as you read through it, it talked about whatever the circuit court did. So I went to the circuit court bench book, and one of the things I wanted to get right away was it talks about indirect contempt outside of the presence of the court. Right? And this is what happens when an attorney puts a name other than the name on his license on a piece of paper. In other words, he uses a middle initial, or a CPA uses a middle initial, or a doctor uses a middle initial, or anybody else uses a name who's a licensed professional other than the name that's on their license. That's contempt of court. That's my opinion. Certainly for attorneys. I can't say for the rest, but I have an issue with an attorney, so I'm going to use it. A civil action is commenced by filing a complaint with the court. Well, that's simple enough. It must set forth a specific factual allegations stating a claim upon which relief can be granted and contain a demand for judgment. What? You must demand judgment. Okay. Filing a complaint with the court. Well, who do you file complaints? Who do you file something with? The clerk. Who's the clerk of probate? The judge. Send it to the judge. Send your complaint to the judge. Unless waived by the court, blah, 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 statute of limitations, forget it, civil procedures that apply, filing a complaint. Now, this is out of the civil procedures. So, civil action is commenced by filing a complaint with the court. How come I didn't put that in there? Jeepers, man. Well, we'll get back to it. Because then it talks about serving it, and it says that the court can do it. Let me hang on just a second. Okay, this is what I wanted to find. So this is out of the civil procedures of Michigan, and right. So it says there's one form of action. It's called a civil action. The civil action is commenced by filing a complaint with the court. Probate court. The judge is the clerk. Send to the probate judge. Summons, issuance. On the filing of a complaint, the court clerk, well, that would be the judge, shall issue a summons to be served in accordance with some other stuff. A separate summons may issue against a particular defendant or group of defendants, duplicate, blah, 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 form. The summons must be issued in the name of the people, the state of Michigan, under the seal of the court. And I believe that just made it a subpoena, not just a summons. And subpoenas are used in courts of chancery as part of an equitable remedy. So, each allegation must be pleaded clear and concise. Statements must be signed in accordance with 214. Statement of claim, a complaint, must contain the following: a statement of facts without repetition, on which the pleader relies, stating the cause of action and a specific allegation is necessary to inform the adverse party the nature of the claim and adverse party is called to defend, and a demand for judgment for the relief of the pleader seeks. If the pleader seeks an award of money, a specific amount. If the claim is for a sum, otherwise a specific amount may not be stated, and the pleading must include allegations to show the claim is within the jurisdiction of the court. Declaratory relief may be claimed in case of actual controversy. Pleading special matters. So here's one of them: legal existence. Almost all these debt collectors, the name of the bank on your mortgage, they don't have any legal existence. It's not the name of the bank. Just take the name the way you see it and go. If it's a bank, it has to have a license to be a bank within the state. Go find a license with that exact name on it in the state. You're not going to find it. And when you don't find it, well, that means you don't have any legal existence. Along those lines, Consumers Energy, which everybody in Michigan would say, well, that's the utility, is not the utility. It's a fictitious name of Consumers Power Company of Michigan, which was incorporated by Consumers Power Company of Maine. But Consumers Power Company of Maine didn't get a certificate of authority to do business in Michigan. So there is no Consumers Power Company of Michigan, and therefore there's no Consumers Energy. I don't care how big their building is, they don't have a legal existence. Condition precedent. So, okay, fraud, mistake, conditions of mind. These are all different things, special matters that you can plead in a civil action. You can plead fraud. Action on policies of insurance. This is your title insurance. If you bought a house, you got title insurance, and they're supposed to protect your title. They look at one. What did I do with it? There it is. Button. Policy of title insurance, right? Go find your title insurance. You got one. This policy insures you against actual loss, including any cost, attorney's fees, and expenses provided under this policy resulting from the covered risk set forth below. If the land is an approved residential lot for which they're located, 1 to 4 family residents, yada yada. Your insurance is effective on the policy date. The policy covers your actual loss from risk described under covered risk. In the event of creating, if the event creating the risk exists on the policy date or to the extent expressly stated after the policy date. Okay. And the policy amount is shown in Schedule A. Here's the covered risk. Someone else owns an interest in your title. Someone else has rights affecting your title. Someone else claims to have rights affecting your title. Someone else has an easement on your land. Someone else has a right to limit your use of land. Your title is defective. Any other covered risk 1 through 6 after the policy date. So even if these happen after the policy date, they're still covered. Well, that's what's happening in a foreclosure. Somebody's coming saying they got an interest in your property. Someone else has a lien on your title, including a mortgage, a judgment, charge, lien. Someone has encumbrance on your title. Someone else claims to have rights affecting your title. You do not have both actual vehicular and pedestrian access to and from the land based on legal right. And that's because they never properly registered your driveway permit. And if you look at a drawing, a plat map of your property, the driveway isn't going to be connected to the road. Driveway is one word. I showed a video on this, and Ro got hers, and it says drive, and you can see where they drew a big box around her property, right? Your property isn't attached to the right-of-way. Your property is vacant as far as the law is concerned, because you never got access to the right-of-way. And that's why if you give a cop that driver's license with that address, well, you're a vagrant, because that house isn't, it's not attached to the right-of-way. And it goes on and on and on. All these different things, right? Our duty to defend against legal actions. We will defend your title in any legal action only as to that part of the action which is based on a covered risk and which is not accepted or excluded from coverage in this policy. We will pay costs, attorney's fees, expenses, and so forth. And they're going to say, well, yeah, but you have a mortgage in your property. And you can say, no, the bank didn't sign the damn paperwork, and show them the frickin' title or the warrant. Show them the deed of trust or the mortgage. Better yet, go back and find the application, which is in your closing paperwork, which is probably all still with your closing agent, and you'll see that the bank never signed the application. So they couldn't have given you a loan. And so all that money you're putting into this escrow account that's created these securities, that is your property, because you put securities down based on the agreement that you were going to get a loan from the bank. And the bank never signed the paperwork. And now you'd like to have your property back. All right, this is huge, man. Somebody better go try that. I don't have a house. I can't try that. I'm trying something different. Right, insurance, actions on a written instrument. Well, that would be a contract. If an action on a written instrument, the execution of the instrument and the handwriting of the defendant are admitted unless the defendant specifically denies. Right. Where is the signature of the defendant, which is the person you're going to be calling the defendant? Now, in a foreclosure, right, everything goes through the attorney of record. Because, again, the bank is not foreclosing on you. The name in the plaintiff box is not the name of a bank that has a license to do business in your state. It may look like it, but if you go try to find it, you ain't going to find it. Right, so there's lots of different things you can do it on. And this is getting a little bit longer than I wanted it to be, so I'm going to get to what I did, because I got to get back at it and see what's going to happen with it. So, this is what I did. I said to do a complaint, and so in Michigan we have this really simple form called the summons and complaint. Some places they just call it a summons, which is okay, because as you'll see, there's no place on this form where you do the complaint. You're supposed to, the words, you add it separate. Right? So if it's just called a summons, it's really the same as what I'm about to show you. But in Michigan, you have these choices, right? You could judicial district, circuit, or county. Kent County Probate. It's because the judicial circuits and judicial district aren't the same as the administrative county of the state. But that's what Kent County is. And I don't know if I should have put it all caps, but I did. Anyways, the address of the court. That's simple enough. Put the phone number. And then I'm the plaintiff, right? My proper person. Care of my business, because my business does use this address, but my proper person isn't registered anyplace. And Consumers Energy, One Energy Plaza, Jackson, Michigan. Yep. So notice the defendant. So I've sent this in with the complaint, and if it's done the way, and I mailed it directly to the Chief Judge of Probate for Kent County, Michigan. And so if it was to work, then he would be the one going here, issued, this summons expires, and he would be the court clerk. And it's in the name of the people of the state of Michigan. That's what makes it a subpoena. And they got 21 days to answer. And it says complaint. So this is the complaint part from here down, but it says instructions. The following is information that is required to be in the caption of every complaint and is to be completed by the plaintiff. Actual allegations and the claim for relief must be stated on additional complaint pages and attached to this form. Okay, so, well, is it in the family division? Is there another case involved? That'd be more like for divorce and name changes and stuff like that. The family division. Because in Michigan, they took part of the probate's duties and they put it in this thing called the Circuit Court Family Division, or the Family Division of the Circuit Court. I'm not really sure which way it goes, but it's still part of probate. General civil cases. There is no other pending resolved civil actions. Right? I don't have another court case against these people. So boom. If I had, if you were involved in a case right now, then you would click this one and you would put what it is, and you would be complaining about that case is the problem. This is your counterclaim, right? I'm not counterclaiming. I'm doing a new complaint. You would have that information. But this is, here's the venue. Include city, township, or village. Well, that's outstanding, because I want to be in the township of Oakfield, Kent County, Michigan. That would be my domicile. And the defendant's in the city of Jackson, Jackson County, Michigan. And the place where it took place is here where I am. And then signed it and, put your signature on it. Okay, so that was the... And this has 2 pages, but, you don't do the second page, because if the judge agrees, he's going to do this. Right? The court shall issue. On the filing of a complaint, the court clerk shall issue a summons to be served as provided. I'm not supposed to do it. They're supposed to. Only the court can call you to court. Right? Some private individual can't call you to court. It has to be the court calling you to court. Okay. Now here's the blah, blah, blah that went with that. So the first thing I did is I said, I'm going to have them take judicial notice. Want the court. I asked the court to take judicial notice that due to mistakes in official records, my proper person, Robert Amarilewski, complainant, is the victim of an enforced disappearance from the civil records, requiring my seeking the court's protection of my physical person and estate under the Estates and Protected Individuals Code until my domicile in the county is certified and confirmed for the record. I endure, and that's why I made a mistake. I endure, have an antitrust. I should have proofread it one more time. I endure an antitrust-caused civil disability because the state registrar didn't registrar me properly. Adjudicative facts. Somewhere in all that stuff, they want you to put each fact, right, that you're basing your case on in its own paragraph. So, Consumers Energy hereinafter respondent has never signed a contract with complainant or a personal representative of complainant's estate regarding account, number, whatever. Well, that's the fact. I don't have anything from Consumers Energy with their signature on it. Complainant alleges that respondent is not a utility and has no legal standing. Corporate entity documents available online from the Michigan Department of Licensing and Regulatory Affairs attest that the respondent is an assumed name of Consumers Power of Michigan an entity allegedly incorporated by a sole incorporator named Consumers Power Company of Maine. Consumers Power Company of Maine did not acquire a certificate of authority as mandated by Michigan corporate law for foreign corporations to obtain, thus ensuring Consumers Power Company of Michigan and its assumed names to be void of legal capacity. Respondent refuses to identify the creditor and validate alleged debts owed, contrary to the Federal Trade Commission, Fair Debt Collection Practices Act, and the 1981 PA 70 Regulation of Collection Practices. So in your state, you're going to have something to do with collection practices also. Should list both of them. Anybody who's trying to collect a debt, right? That I'm doing this against Consumers Energy. You can do it against anybody who's trying to collect a debt. Respondent claims to be regulated by the Michigan Public Service Commission, but no rate book is filed in that name. A rate book for Consumers Energy Company is filed, right? But not Consumers Energy Company. But its contents are contrary to the Michigan Administrative Code. It's without tariff sheets, franchise with political subdivision, and commission stamp of acceptance. Further, the Constitution of 1963 of Michigan, Article 7, subsection 29, mandates utilities acquire a franchise from the township. On June 5, 2015, Jason M. Milestone, representing Consumers Energy under its legal department, used the mails to deliver a simulated legal correspondence, disputing any obligation to verify debts mandated by FTC, Fair Debt Collection Practice Act, nor any obligation to provide a copy of the franchise required by the Constitution, unless ordered by court subpoena. Jason subscribed this instrument using a fictitious name while in his official capacity. Complainant believes this is a violation of the Michigan Rules of Professional Conduct and an indirect contempt of the Supreme Court. All legal department attorneys listed on correspondence attached as Exhibit 1 are using fictitious names in place of their legal names certified yearly with the State Bar of Michigan in their official capacity. I show you what I'm talking about. Here's that letter. So I had asked them to verify the debt, basically, right? And your June 1st correspondence was forwarded to my attention. Be advised, Consumers Energy has no obligation to comply with 809 of the Fair Debt Collection Practices Act. This is the case because Consumers Energy is seeking to recover debt owed directly to the utility. Regardless, I am enclosing bill summary, whatever. Your correspondence also requests a copy of utility franchise agreement with Oakfield Township. Well, it was actually the Township of Oakfield. Consumers does not voluntarily produce records without court subpoena unless a request involved a customer seeking account information. You should direct your request for the clerk of the township. Okay, Jason. And then old Jason, right? Jason M. Millstone. Well, there's that middle initial. I don't believe that if we were to look at the role of attorneys in Michigan, that Jason M. Millstone will be found to be an attorney. Jason Mark, Jason Matthew, Jason something Millstone. Could be. It's M-I-L, Millstone, not Milestone. Sorry, Jason, I spelled your name wrong. And I don't know if you can see this, though, but, right, so all these other attorneys are all using the middle initial on an official piece of paper. Company letterhead. They're simulating the legal process. That's what I say. All right, so that was what that was about. Close some of these out so I quit opening them. On June 22nd, 2015, complainant received correspondence from the respondent's representative, Randy Richards, Customer Care Service, attesting respondent's refusal to provide certificate of good standing for Consumers Energy because if they're any corporation in Michigan properly formed has a certificate of good standing unless ordered by court subpoena. Exhibit 2 also alleges complainant's inclusion on some internal report for threats of violence with no due process, slandering my God-given character. That would be this letter here. Well, part of it. Thank you for your email inquiry about the account at that address. I understand you have some concerns regarding the meter reading. You requested copies of Consumers Energy Certificate of Good Standing and assumed name certificates. We do not provide this information unless provided a duly ordered court subpoena. Ba-ding! Gonna try to get you one, Randy. And they wanted to send me my 18-month itemized statement also. Now you have to understand what happened is back in May, they came and they put one of those new smart meters in. And then the next month they get a bill that said, hey, you owe us almost $3,000 because we hadn't read your meter in 15 months and we took it off the wall and brought it in, and we realized now that we had not charged you almost $3,000 in power. So we're going to take your last 15 months of payments and go apply it to the back bill, and now you're $3,000 behind, and please make a payment or we're going to shut your power off. Well, so I went through the steps of what it says to do to try to point out a violation, and the state didn't seem to care. The Michigan Public Service Commission didn't care. The governor didn't care. The frickin' attorney general didn't care. Civil rights didn't care. Nobody really seemed to care. And here on July 31st, I'm up on my roof doing a roof repair. Got half the roof tore off. Oh, they turned power off. Yeah, it was my last Friday. And, I was able to get it back on, but it took every penny I had to get it on long enough so in 30 days I need to pay them another $500, so they're going to turn it off again. And another $500 a month after that, and another $500 after that, and another $500 after that, until the $3,000's paid off. So I got a lot of skin in the game. So anyways, the meter reading were estimated when the meter was exchanged for a smart meter. Those meter readings were estimated as a result of threats or violence remark on the account. The meter reading technician did not feel they would be safe going to the meter. But when you looked online before, it showed that they were reading one as was actual and estimated every other month. They're saying it was estimated on this for the last 15 months. If you have any questions about the threat and violence remark in your account, please contact. I could contact them. Now I decided to contact the probate judge instead. Thanks, Randy. Your request for copy of picture identification, meter reader, we are unable to comply with request under that rule in the attached copy of the rules. Right, so they couldn't follow the rules and provide me a picture identification of consumer's meter reader who said that, hey, the meter says you owe us $3,000. We can't give you his information. Sorry. And then some other blah blah, right? So, basically that is what I was making hay out of. And then statement of a claim for relief. And enduring the above mentioned civil disability compels me to demand a declaratory judgment from the court of probate, the People's Conservator, in favor of the people of the state of Michigan generally, and myself specifically, for the return of all unjust gains controlled by Consumers Energy and others by reference to ID, whatever, to the rightful owners generally, and to myself specifically, an accounting of account number, whatever, copy of typical bill attached, and return to me what is rightfully mine. Right? I don't know how much it is, just whatever it is, whatever the unjust gain was. I'm not saying I get free electricity. I'm saying Consumers Power isn't the utility. They're acting as an agent between me and the utility, and, charging me for things that they don't have any right to charge me for. Because they don't have a license to do business in the state. They don't exist. Court order performance and compliance audits on the Michigan Public Service Commission to find out how come the Michigan Public Service Commission, which is supposed to be regulating public utilities, is allowing an entity like Consumers Energy to fleece the people of Michigan. The Supreme Court takes superintending control of any regulated utility found to be formed on fraud, eliminating the people's burden of paying for that which is already owned by the people, because the people own the power companies. That's why it's a public utility. It's owned by the people. Somebody else may run it, right? Somebody's got to go run the damn thing, so we'll hire a company to run it, but we own the power company. They're just turning the buttons. Court enforced compliance with state constitution regarding local government unit fiduciary utility franchises, because in our constitution, under local government or local government, it says that utilities have to have a franchise with the local government, township, city, village. Court order of protection from termination of complainant's electrical energy by respondent or concealed creditor utility, because I really don't know who the creditor of the utility is yet. Or other complete remedy in equity the court deems just. I declare statements above to be true. Right, so hey, that was my complaint. Right, that was my verbiage to go with the summons page. Right, making my proper person care of my all caps at this address against Consumers Energy, just the way it shows on the bill or the way you find it online, to the probate court. And, if the judge agrees, because I've given him probable cause, then he should issue a summons, which is actually a subpoena, as the court clerk of the probate court. And bada boom, and since the venue is here, we might have this hearing down at the township hall. That'd be wonderful. So that's what I'm trying to do, right? I don't know if that makes any sense or not, but that's what I'm talking about. There's people that want, the Pharisees, the Scribes, and Nicolatianes, they want to lord over us, and we need to go to the bishop and probate and say, hey, prove the deed, right? I didn't give them jurisdiction over me. I think the problem is you don't know that I exist, right? Let's put the proof in the civil record, because they're the custodian of the public record. So, okay, and if you can, please do donate, because it's a pretty stressful time right now for myself, but hey, I'm going to deal with it. I'm just saying, it's driven me to do what I'm doing, and I believe that's what the Holy Spirit wanted me to do. So, okay, that's what I can tell you for today. We'll see ya.